Welcome back to Canadian Justice, where we're discussing gender policy and parental rights in Alberta, Saskatchewan, and New Brunswick, and a new paper explaining how these policies may in fact be protective of the charter rights of children, including trans children, by author and professor Stéphane Sèrafin. Stéphane, let's talk about first some of the criticisms that some scholars have made of the Alberta, in particular, policies, which spans from protecting women's sports to pronoun notification in schools to medical interventions for minors. So a number of these policies are justified on the basis of what are called parental rights, but some legal scholars have claimed that parental rights do not exist at all. So how do you respond to that? I mean, I think a lot of parents want to know, do parental rights exist?
I mean, the answer to that is yes. They're quite widely recognized in every facet of our legal system, be it in the common law provinces or in Quebec in the civil law. They're recognized under the Constitution, under the Charter. There's charter jurisprudence that quite explicitly sets out the existence of parental rights. Now, what I think opponents think of when they talk about parental rights is something like parental rights as a proprietary entitlement. It's almost like parents owning their children. You'll see this rhetoric deployed a lot. Whenever people invoke parental rights, it must mean that they think that they own their children. What needs to be understood here, and this is a point we make in our paper, is that parental rights, what they are really, is just rights that parents hold in order to discharge their duties. So parents have duties towards their children. They must act in the best interest of their children. And this makes sense. It makes sense that parents would normally have the rights that go along with those duties. Um, and parents, of course, are generally better placed than, say, the teachers to make these decisions on their children's behalf. And when we talk about parental rights, and it's simply reflecting this basic fact that parents are in the best position to make decisions in the best interest of their children, and so they should have the rights, the powers to do that.
Now, one of the things that you write about in your paper is about the special vulnerabilities of children and how the Charter does offer special protections to children. And that you write the policies of the Alberta government about these issues are actually consistent with the Charter protections for children who are uniquely vulnerable in society. So, what can you tell me about that argument?
So this ties in very nicely to the last point we're discussing about parental rights. The reason parental rights exist is because children are not fully formed adults, and Canadian law, like the law of virtually any jurisdiction, recognizes that they can't make fully autonomous decisions on their own. Someone has to act in their best interest. So usually parents will be doing that, but the state also has a role to play. State sets general guidelines on age appropriate conduct in the for the purpose of help of protecting the rights of the children, the minors in question, but also for protecting the rights of other people in society. We have all sorts of restrictions of this sort in place. And the idea that it's an infringement of charter rights to impose age-related restrictions on such things is frankly contrary to basic structure of our legal order. We impose regulations on smoking, alcohol consumption, even certain surgical interventions, right? They're already restricted, age restricted, different ways in different provinces, but still.
Yeah, so that's one of the things that really stood out to me in my paper is, I mean, the issue of the medical interventions in particular. So you argue, and the medical interventions, as I've said, they range from puberty blockers to cross-sex hormones to sex change surgeries, including mastectomies or what are called bottom surgeries, which involve genitals. In your paper, you argue that these age restrictions are actually in the best interest of protecting children, including trans identifying children, because the medical and scientific evidence on these interventions is uncertain and that there are risks involved. What can you tell me about that?
Right. So the assumption that opponents of these policies appear to make is that children, including trans-identified children, are somehow fully competent to make these kinds of decisions at any age. And this is the other thing that's striking, is that they don't suggest that the ages proposed by Alberta are too high, that we could reduce the age restriction to, say, 12 years old instead of 15 years old. No, they're opposing any kind of restriction whatsoever. And these surgeries, we know for a fact, have certain irreversible side effects. I mean, the sex reassignment surgeries on the genitals, for example, or the mastectomies, those are clearly irreversible. But
Mm-hmm.
even something as benign as, or apparently benign as a social transition. The recent CAS report out of the UK suggests that that has like profound ramifications for a child's social, psychosocial development. So these are not like fully
Yeah, like
benign
any
interventions.
medical intervention comes with a risk of causing harm, and we have to weigh the
Yeah.
harm against the benefit of the intervention. We've got to go to break now, but we'll be right back.